So good afternoon, thank you for coming along today. My name's Gavin Recchia, I'm a partner here at Davis Collis & Cave, and I hope you'll find this afternoon's discussion on Darcy v Myriad, the recent High Court decision, to be interesting and stimulating. Before we get underway, I just wanted to share with you some of the feedback we've had from various corporate clients and other attorneys we work with overseas in relation to Myriad in Australia. In Australia, we're always interested in what the rest of the world thinks of us, so some of the comments, just paraphrasing. Finally, someone's got it right. A cogent, logical, well-reasoned decision. Scientifically solid. This is the decision that others should take note of. Unfortunately, those comments were made last year after the full Federal Court of Appeal decision came down 5-0 in Myriad's favour. The sort of feedback since last month's High Court decision has been probably less flattering, is the best way to put it. Largely, I think there's still just a lot of confusion. People don't know how to interpret the decision. And that's what hopefully we'll try and shed a little bit of light on today. I don't think we'll be able to provide any answers, but hopefully we'll help you understand how to interpret the decision and work out what it means for biotech and for other industries. So, as I said, no, there won't be any answers today. We don't have an answer, I think, unless Lexie wants to give us a scoop this afternoon on what IP Australia is going to come out with. But at least you'll hear, I think, a diversity of views on the decision and the various interpretations of the decision. To help us with that, we're very fortunate to have two guest speakers with us. So we've got Professor Andrew Christie, who's the Chair of Intellectual Property in the Faculty of Law at the University of Melbourne. And then we've got Lexie from IP Australia, Supervising Examiner of Pharmaceutical Inventions. Before we hear from them, I'll give you just a brief background and a bit of overview about the decision and some comments from one particular perspective on how we may look at the decision. So the first thing to note is that there are only 3 claims at issue through these proceedings. So there are only the claims directed to an isolated nucleic acid that were at issue through the Federal Court and the High Court. So the remaining claims in the patent directed to probes, vectors, cells, methods for determining susceptibility to cancer were not at issue at all. Okay, so the first point here is we're not really in that US scenario regarding patentability of methods of diagnosis. So claim 1 of the patent reads, I'll put it up here, an isolated nucleic acid coding for a mutant or polymorphic BRCA1 polypeptide. The nucleic acid containing, in comparison to the BRCA1 polypeptide encoding sequence in secondary number 1 or more mutations or polymorphisms. And it defines mutations with respect to those that are provided in 3 tables and polymorphisms from 2 different tables in the specification. So claims 2 and 3, which are also at issue, depend straight from claim 1. Claim 2 just dealt with the mutations in tables 12, 12A and 14, and claim 3 dealt with the polymorphisms in the other 2 tables. So we don't really need to kind of consider those here at the moment. The first thing to note about the claim, the word isolated is really important here. That was the foundation of Myriad's case. It was also the foundation of the Federal Court decision in first instance, and also the full Federal Court decision on appeal. It's also reflective of the language that until now IP Australia has accepted in relation to nucleic acids whose sequence is the same as that found in nature. The term nucleic acid is also very important here, and ultimately I think proved to be really important in the High Court decision. So the specification defines nucleic acid very broadly, such that it encompasses fragments of the BRCA1 polypeptide, including very small fragments, down to, fragments of the gene encoding BRCA1, down to 15 nucleotides. So the effective scope of claim 1 is any nucleic acid of 15 nucleotides or more, up to about 100,000 nucleotides, that's removed from its natural setting, so it's isolated. It encodes, by virtue of the length, at least 5 amino acids of BRCA1, so it encodes a polypeptide or a peptide, and it has a mutation, either a mutation defined in one of the 3 tables defined here, or polymorphism as defined in 2 other tables. Right, so also important here in the context of the decisions is the utility of the invention. So in simple terms, the mutations and the polymorphisms determine susceptibility in BRCA1, determine susceptibility to breast and ovarian cancer. So identifying those mutations and polymorphisms in DNA isolated from a subject allows the diagnosis of susceptibility to cancer. Right, so that sort of background. We'll start with the full Federal Court decision. So they reiterated the decision of Justice Nicholas in the first instance, with a unanimous 5-0 decision in favour of Myriad. So at that point it was 6-0 to Myriad. The High Court came in and reversed that 7-0 the other way. So if it was a 2-leg soccer tie, we'd have a match-fixing inquiry. The question is, how did we get such a radical reversal of a decision? And I think the answer lies really in the approach to the manner of manufacture test, and the manner of manufacture law that underpins what is patentable or patent eligible subject matter in Australia. I won't go into any detail about that here. I'll leave that. Andrew's, I think, going to talk about that. And also really reflects the interpretation of what the claims protect, which is what we'll see shortly. So the full Federal Court did kind of look at the big picture in relation to gene patents. And they said the case is not about the wisdom of the patent system, it's about the application of Australian patent law as set out in the Act and developed by the courts since the Statute of Monopolies. It's not the role of the courts to decide whether, for moral, policy or moral or social reasons, patents for gene sequences should be excluded from patentability. And they went on to talk about the various reports and Senate committees and everything else we've had over the last many years into gene patents, each of which has said there should be no exclusion for gene sequences from patentability. So they really kind of took a particular approach. They looked at the manner of manufacture test as was set out in the NRDC High Court case, and they concluded that the claims resulted in an artificially created state of affairs for economic benefit, therefore constituted proper subject matter. They did that by looking at the gene sequences as chemical compounds, the nucleic acids as chemical compounds. And they said the isolated sequence is different to that the gene that exists in nature. Nucleic acids are chemical compounds, the claims are directed to these chemical compounds and they should be judged in that way. All right, so it was really about, as I said, compounds, not information. Now they also took the unusual step of openly criticising the US Supreme Court in their decision. And I'll just read some of this to you. It's difficult to reconcile that court to the Supreme Court's endorsement of the reasoning in Chakrabarti. Chakrabarti was a case in the US about a genetically modified microorganism, with its rejection of isolated nucleic acid as eligible for patentability. With respect, which of course is what you say when you're about to not show any respect. The Supreme Court's emphasis on the similarity of the location and order of the nucleotides existing within the nucleic acid in nature before Myriad found them is misplaced. It's the chemical changes in the isolated nucleic acid which are of critical importance, and this is what distinguishes the product as artificial and economically useful. So then went on to say that Myriad's claim, properly considered, is not, as the Supreme Court considered, concerned primarily with the information contained in the genetic sequence rather than the specific or chemical composition. So herein lies the crux of the reason we had the reversal of the decision from the Federal Court to the High Court. It's really about what is the claim directed to. So the Federal Court took this view. It was all about chemical compounds, and it's the chemical changes when you isolate it that's important. It's talk about specific or chemical composition, not information. The High Court preferred the US Supreme Court's view and their position and said it's about information, so focused on information. And that's particularly relevant in the majority opinion. So with the High Court decision, we had unanimous 7-0 decision, but there were 3 opinions. There was majority opinion from 4 judges, then 2 minority opinions from 2 judges and 1 judge. Now, in focusing on the informational content of the nucleic acid, the majority judges in particular do so by emphasising the context of the claims and the utility of the invention in enabling the determination of susceptibility to cancer. So in that regard, again, just some extracts from the judgment here. Now I've not put the whole, I want to read you a passage from the judgment here. I haven't put the whole thing on the slide because it's a bit too long, but just part of it. There are perhaps 2 ways of looking at the role of genetic information in characterising the subject matter of the claims. One way is to say that the chemical formula of any given isolated nucleic acid is defined in part by the sequence of nucleotides which it reproduces, and in that sense is defined by the information embodied. Another way is to say that the particular chemical compound embodies and conveys the information. And the important part here, I think, is about the middle of this slide. The latter approach gives the priority to the informational aspect, which is its importance to the utility of the claimed invention warrants. And they went on, with proper regard, when proper regard is paid to their emphasis on genetic information, the subject matter of the claims, so it's the claims at issue in this case, lies at the boundaries of the concept of manner of manufacture. So one reading of that is that the problem lies really in the utility of the subject matter. It's used as a diagnostic of disease. So given that all it's being used is the information that exists in the molecule, and that being the same as the information in the molecule existing in the cell, to determine susceptibility to breast and ovarian cancer. So that, and I think that last statement lies at the boundaries, is particularly important there. Would a different decision have been arrived at had the utility been different? All right, the majority in the High Court decision were also particularly concerned with what they called the potential chilling effect on innovation. And they mentioned that phrase, chilling effect, 4 times. Now, in relation to that, they talked about an odd consequence, which is that the claims could be infringed without the infringer being aware of it. So they talked about anyone isolating BRCA1 DNA from a patient, even for a purpose that's unrelated to Myriad's patent, may, without intention, isolate a fragment that includes one of those mutations or polymorphisms in BRCA1. And they wouldn't know that until they'd isolated and sequenced the fragment. So they then went on to say that that consequence, coupled with the large and indeed unquantified size of the relevant class of isolated nucleic acids, remembering the way the claim is interpreted, the scope of the claim, talk about nucleic acid, by virtue of how nucleic acid is defined in the specification, encompasses extremely small fragments up to very large fragments of BRCA1. So you've got an enormous range of potential fragments or molecules encompassed by the claim. All of which bear the requisite information, raises the risk of a chilling effect on legitimate innovative activity outside the formal boundaries of the monopoly, and risks creating a penumbral de facto monopoly, impeding the activities of legitimate improvers and inventors. So that's their concern. And those concerns there are stated in relation to the use of the information and the breadth of the claims. So importantly though, the majority went on to say, and they made the point that they weren't concerned with gene patenting in general. What they were concerned with was they were focusing on whether or not the particular claims before them, so claims 1 to 3 of the patent, having regard to the language of the claims, their potential breadth, the implications of protection in these circumstances, this odd consequence of unaware infringement, constituted appropriate subject matter for a patent. Right, and they found they did not. So the question then is, though, how far can we extrapolate from that finding? So on one reading, they took arguably bad claims and found they were invalid. The question is that a decision on the basis of which we want to create law, or is that a case that's decided on its facts and on its merits? There's a lot of discussion about this so-called chilling effect on innovation. In the context of the decision, it's not mentioned in relation to gene patents in general. The majority said this is not about gene patents. It was given in relation to we've just gone through with the context of the breadth of the claims and this issue of unaware infringers. Again, would the decision have been different if the claims had been drafted differently, created differently? So if we consider a claim to a nucleic acid sequence of a narrow class that encodes a therapeutic protein, does that fall foul of does it have the same problems? Does that result in a large new field of monopoly protection with potentially negative effects on innovation? Does that have a chilling effect on activities beyond those formerly the subject of the exclusive rights? Does that result in the court having to assess important and conflicting public and private interests and purposes? So I'd answer no, it doesn't. Can the substance of a nucleic acid sequence then be other than information? That's really kind of the critical thing. So is it information then in relation to the utility is in the information that it carries for diagnostic purposes, or if you're dealing with a nucleotide that encodes a polypeptide for therapeutic purposes is that substance other than innovation. Other than information. All right. So we're all looking for a line to draw here to decide what's in, what's patent eligible, and what's out. So IP Australia tried to do that with their consultation paper in suggesting excluding naturally occurring nucleic acids encoding polypeptides and cDNA. And Lexie will obviously talk more about that shortly. Arguably, in one reading, that may be already too broad. Others obviously disagree with that. Perhaps if there's a generality to be drawn, it should be limited to naturally occurring nucleic acids encoding polypeptides where the informational aspect is central to utility. So, for example, in biomarkers. Again, others will feel differently. But wherever we construct a boundary, someone's going to be unhappy with it. And around the edges of those boundaries is where we're obviously going to see the disputes arise from both sides. A question, should we be looking for a line at all, or is it a case-by-case analysis? Either way, ultimately the High Court has created more uncertainty, I think, with this decision. Uncertainty is bad for industry, it's bad for innovation, and it's bad for investment. So the sooner we get some certainty back into proceedings, I think the better off we'll all be. Others may differ in their view, but I don't think gene patents are necessarily dead as a result of this decision. I do, however, think we need to be wary to avoid the US downhill spiral that was created by Myriad and Mayo in the US. So recently in the US we had an Ariosa v. Sequinom decision of the Federal Circuit Court of Appeals, and they said they were constrained by the sweeping language of the test set out in Mayo. And one of the judges there, Justice Lynn, said it leads to the unintended consequence of excluding a meritorious invention of the patent protection it deserves and should have been entitled to retain. Now, I don't think the High Court's Myriad decision creates similar constraints in Australia, and importantly, method claims were excluded, were not touched in the Australian decision. But I do think we need to be careful not to unwittingly start to create constraints like that by being overly prescriptive and drawing the wrong line in the wrong place. Right, that's enough from me. I'll now hand over to Andrew Christie, Professor Andrew Christie from the University of Melbourne. He'll obviously give you a much more academically rigorous analysis of the decision than I have, and I look forward to hearing his views. So please join me in welcoming Andrew.
Thanks very much, Gavin. And I want to start by saying what a great idea it was of you and your colleagues at Davies Collison Cave and your colleagues at AusBiotech to have a seminar on this High Court decision. Not every High Court decision on patent law warrants its own seminar, but I think this one does. Can I also say what a great idea it was to ask me to come and give it, because it allows me to indulge myself enormously. I'm passionate about patent law, and within patent law there's no more interesting or more important topic than the fundamental question of manner of manufacture, that is to say the fundamental question of what is an innovation, what could ever be patentable independent of the issues of novelty, inventive step and utility. So thank you for giving me the chance to indulge myself. Now, I won't indulge myself for as long as I might, unconstrained, because there's a very knowledgeable audience here. I looked at all the name cards before you came. There's many people in the room who know a lot about this, and I'm very keen for me to hear your comments and hear your questions at the end. Also, Well, I'll just stick with that. I think it is a very knowledgeable audience indeed, and I'm very keen to hear your comments and questions. And I don't purport to have all the wisdom, is what I think I should be saying. Also, perhaps I should say up the outfront, I didn't write the decision. A lot of people afterwards in the drink session elsewhere have come up to me as if I wrote the decision and saying, "Well, it's really bad." And I'm saying, "I'm just the messenger, so no shooting, please." Okay, now with Gavin's excellent account of what was decided, it's very tempting to go to the end game, which is the so what. So what follows next, as Gavin's last slide does. I think with this decision, that's a mistake. I think we do have to actually join the dots. We do have to carefully look to see things that normally we wouldn't worry about. Normally just say, oh, what was the claim? What did the court decide? Oh, I know what's going to happen next. This case, I think we have to go through the how and the why before we can be a bit more confident about the so what. So that's what I'll be doing in my 20 minutes from here on in, is predominantly looking at how did the court go about this. It's very, very interesting. Yes, it's very academic, and you know, for me it is simply an academic issue, but for those of you in the audience, most of you at least, this is really practical. I know that. So it matters. You know, you've got businesses, or you've got businesses to advise about this, whereas for me it's just an academic exercise. So again, I'm very keen that you get the chance to make the comments that you wish to do so. If we start with the how did the court do this? Now, in some respects, it's very unwise to speculate about which judge wrote the decision in a majority decision. No doubt there was some joint fingers on the keyboards. But with the judgment of the four, which is often called the majority, that is to say Chief Justice French and Justices Kiefel, Bell and Keane, it can be no doubt that at least part of this was very driven by the Chief Justice. How? Because if you go and look at the most recent High Court decision in patent law, which was also on manner of manufacture, also on inherent and patentable subject matter, Chief Justice French has his own single decision at the start of Apotex v Sanofi. And in that, he's very, very careful to talk about one particular thing, and that is the issue of when it's appropriate for a court to determine these sorts of policy issues and when it isn't. And in this judgment, you see exactly that language again. And in fact, I think the fingerprints of the Chief Justice is all over that majority decision. So what that, and I will focus almost exclusively on that judgment of the four, what they say is this. Now, none of those dot points are in any way radical for all of us who've grown up with the NRDC case from nearly 50 years ago. Because in NRDC, the High Court, the last time it spoke with such broad and fundamental language, said exactly that. They said the issue of what is inherently patentable has to be judged on a case-by-case basis. You can't tie it down to a verbal formula, and you must take account of policy considerations. It's a fundamentally policy-based issue. And of course, we've all read that, myself included, and go, yeah, and then we go on and say, well, there is a verbal formula. The High Court gave it to us in NRDC. Here it is, and this will do the job. And I've been guilty of doing that in my teaching, and no doubt in when I've been thinking about patent law. And I suspect there's many in the room, advisors in particular, who've also been, like me, a little bit intellectually sloppy and just fallen into saying the NRDC test is the test. That's all there is. And indeed, that's exactly what the judge at first instance in the federal court, it's exactly what the full bench of the federal court, the 5 judges in the full court on appeal, did. And for most of us going along, we might have thought, well, that's all there is to do. You just ask, is it an artificially created state of affairs? And does it provide economic utility? And if the answer is yes and yes, the answer is clear. We have patentable subject matter. What the High Court has told us is a wake-up call for the sloppy, the intellectual sloppy, of which I'm as likely to have been as guilty as anyone in the room, is that whilst that will work most of the time, there's certain times when it won't. So for the large class of cases, it will suffice. Now, the large class of cases are actually the ones where really the issue never comes up. We don't ask questions about, is a new pointing device a manner of manufacture? Because we know it's an artificially created state of affairs in a field of economic endeavour. It's only at the margins that we would ask the question, and then it is when we're at the margins that we have to ask the elaborated questions. And this is the key part of how the High Court, I think, has changed, not changed because they said it's always been so, perhaps I should put it this way, reminded us that when you're at the boundaries, you have to take into account policy considerations. So when you have, and this is their words about what they had in front of them, Gavin's given us very clearly the actual words of the claim, but to them they had subject matter that they could characterise as unimagined technologies with unimagined characteristics and implications. And they said, in that situation that we find ourselves with the Myriad claims 1 to 3, we're at the boundaries, we're at the very edges of the concept of what's patentable. We're not in the core, we're at the very edge, at the boundary. And when you're at the very edge, you need to do more. You can't just default to the artificially created state of affairs of providing economic utility test, the 2-limb test. More needs to be done. What is that more? Because we do now have to do it, at least in areas like this. And I would add, although I won't make substantive comments about it, if anyone wishes to, they can ask about it in the question and answer or in the drink session, but I would add equally so for computer implemented inventions, the consequences of this decision. In fact, I would add probably more so. Some of the drink sessions elsewhere I've been talking about it, I've said, people come up to me and say, well, I'm interested in computer implemented inventions. I say, well, actually, I think the news is even worse for you. So at least, if not more so, for computer implemented inventions, because they're also at the boundaries. So what are these other factors that we have to take into account? Well, interestingly and helpfully, at least from an academic point of view, they've been enumerated for us. There's 6. Those first 2 are in fact the NRDC test. So in a sense, what the High Court has very cleverly, and I don't mean cleverly in a derogatory way, I just mean cleverly done, is said, really there's all these factors that have to be taken into account. The first 2 of which are the ones that we've slotted into thinking perhaps are the only 2 we have to. Because that first factor is the factor from NRDC of whether or not we have an artificially created state of affairs. And that second factor, of course, is the second limb of the test from NRDC, is the claimed subject matter of economic utility. If the answer is straightforwardly and clearly yes, and there's no doubt about it, that's where we've always stopped for the last 48 years, and most of the time we can. But we can't in the cases at the edge. In the case at the edge, we have 4 other factors to consider, 3 of which we're told are primary, they're the ones that I've darkened, and the 5th one we're told, by implication, is secondary. And again, if this is quite important and interesting, but totally understandable. The High Court now is saying the other factors that have to be taken into account are primarily ones of national determination. This is an area where nation states are allowed to be very jealous about determining what gets into the patent system. And as I've said elsewhere on other occasions, I reckon there's only 2 parts of the patent system where nation states can justifiably be jealous in their determinations. Right at the very front end, this is the front end question. What subject matter could ever have a patent granted for it? And right at the very end. And that is when you get things like, what exceptions might we have? Should they be research-based? Should they be ethically based? Whatever. We've got a front end issue here, and the High Court's recognised that by saying international obligations and the laws of other countries, whilst not irrelevant, are not primarily the issue here. Primarily the issues are 3, 4 and 6, and of that, particularly 3. So let's have a look at those, look at 3, then I'll come to how the court applied those 6 factors to the subject matter in front of us, and I think then we can start, at least from my perspective, get a better sense of the so what follows. On this 3rd factor, and this is, I think you can, to my view at least, this seems to be the most substantive of the issues in the case, and probably the most substantive of these other factors that have to be considered. The High Court helpfully told us what is the purpose of the patent legislation. Now, there's no surprises here. I don't think anyone in this room would have any argument with the thrust of what is said in that quote. I wish I'd come up with the quote. It's neat. You know, encouraging innovation by means which do not stifle it. The way I used to talk about it, and probably still will because I don't want to be seen as just parroting the High Court, but I used to say to people, the purpose of the patent system is to inflict short-term pain for long-term gain. Short-term pain, yes, we recognise that we're creating exclusive rights, call it a monopoly if you like, which will allow for monopoly pricing, hopefully for the inventor, will exclude competitors for a set period of time. But eventually, once the patent has expired, free competition, and also in the long term, we're providing the right incentive for innovation. And I think everyone in the room accepts that that's the point of the patent system. This is a neater phrase, I like it. Encouraging without stifling. Now, of course, the trouble with neat phrases is whilst they embody a lot, but they don't necessarily tell you how to get there or measure it. And the High Court sort of elaborates here, sort of says, so in particular, these are the things that should be brought to account. And Gavin's, I highlighted a couple of these at least, but let's just have a look at this. They said, in particular, you need to ask these questions. Whether allowing patentability of the subject matter in question would create large fields of monopoly protection with potentially negative effects, the chilling effect thing. And to me that's interesting because that's American language. I can remember a time when people in Australia, if they're talking about chilling effects, were talking about the air conditioning being up too much. This is American academic jargon, particularly economic jargon that's been adopted in the law schools, but it's influencing and has influenced our High Court. Chilling effects, and this last one, does it involve the court, as distinct from the legislature, in doing something that would involve important weighing of conflicting public and private interests? That's really of concern, I know, to Chief Justice French, because he would take the view, if what you're asking the court to do is something the court should not be doing, but the legislature should be doing instead, the court won't do it. And that was very much worrying him here. So we'll see in a minute how it was the case that he and his court could make the decision that they did. So that's the how, and I'm going to come back to the how when I go through the why, because I think you can see it in the abstract, see it in the principles, and go, yeah, that's interesting. But to really try and understand it, I have to keep going back and saying, let me now see how they did it here. Why this time round, when they applied those principles, did they get to the answer that they did? So let's do that. Let's turn to the why did the court reach the particular decision that it did, which, as Gavin very clearly and helpfully explained to us, was, despite what earlier judges have said, no, none of claims 1 to 3 were inherently patentable. Okay, one of the first things they said, well, actually absolutely critical, was for them to make a finding that claims 1 to 3 lay at the boundaries. Why? Because as we've just seen, where the claims lie at the boundary, you have to do that extra analysis. You can't be intellectually lazy and stop at manner of manufacture equals artificially created state of affairs plus economic utility. Now, you can say that there's a bit of, I mean, if one wanted to be critical, and I'm not, but if one wanted to be critical of the High Court, you'd say there's a little bit of circularity here. I mean, because they've concluded that the claim lies at the boundary, which now means they have to go and apply the factors. But how did they conclude it lay at the boundary? And it's not so much circular as I think when they looked at the claim, as we'll see in a minute, they knew that in its proper construction, in their view, it lay at the boundary. So the first thing is the claims lie at the boundary. How do we know that? Well, firstly, this is not as simple as being able to say, as the earlier courts had done, that this claim is to a long molecule in whatever form. That would be to elevate form over substance. And this is, this is a really important point. None of us deliberately elevate form over substance, but I suspect for many of us in the room who, are sort of patent aficionados or geeks or whatever, and don't mean this inappropriately, because I have the utmost respect for them, but patent attorneys perhaps are the most extreme example of that, followed closely by patent lawyers and then patent law academics, of which I'm one. But we get so caught up in the drafting. We tell our students, the claims are all that matters and the wordings of the claims is all that matters. Everything's determined by the exact wording of the claim. That we forget to look at it the way we're reminded that courts will. Courts aren't patent attorneys, with wigs. They're people who are reading claims with an understanding that you have to get a sense of the substance here because it's inherently policy-based. And they're saying that it's not appropriate just to see these claims as being a claim to a molecule, because that's more than that's not exactly what it is. What is it? And Gavin said that they were rightly observing how, and they said here, the focus, or if you like, really the substance of what was embraced within the claims was information, genetic information, namely the information for which the sequence of nucleotides, as claimed, coded. And they say, really, the claims are a medium to storing the information. Now, parenthetically, and for your purposes, perhaps not particularly relevantly, but again, if you're interested in computer-implemented inventions, pay attention. Because really, the court's concern with computer-implemented inventions has been very much this one, that all you're claiming really is the abstract concept, the information, if you like, the algorithm, the procedure. And then you dress it up as a product claim by saying, as implemented by a computer. It's a little bit like that here, a little bit like the court saying, you're really claiming the information for which the nucleotide sequences codes, and you've dressed up the claim as a product claim, a claim to the nucleotide sequence, as a way of putting some form, some substantiality, so if you like, some material form around that claim. And they say properly construed, you know, we're away to this. In a way, they're saying the 6 judges below had the wool pulled over their eyes. Now that's not true, because they were very smart judges, right? They didn't have the wool pulled over their eyes, but they were doing what most of us had thought was all you had to do. You read the claim, looks like a claim to a physical object, you know, chemical compound. Well, that's and so long as it's artificially created and has economic utility, that's enough. They're saying, no, don't. To do that would elevate form over substance. Pay attention to substance. Finally, and I think most importantly, is the word made. Others have heard me say this before, but I think the word made in this judgment does a lot of intellectual heavy lifting, and to be honest, I think it will in the future. When asked to sort of try and, when I asked myself to try and say, do I think I understand the majority judgment? And I can't be certain I do, because I can't get inside their minds other than through their words, and I've read them carefully. The best I can say to myself is, I must pay big attention to this concept of making. That is to say that they're really saying that you can consider artificially created to have a number of versions. The nucleotide sequence in Myriad was artificially created because you could say it was isolated. And that's exactly what Myriad was arguing. It's exactly what the judges at first instance and on appeal said. And the High Court's saying no. It's not artificially made when you understand artificially make means to make. Myriad didn't make that. They isolated it, but they didn't make it. That seems to me really key. So for those 3 reasons, and in a sense they're quite all interrelated, it was the court, they were the reasons the court could say to itself, well, this claim does lie at the boundary. When you look at this claim, when you look at its substance, not its form, and when you look at what it really does, and you look at it in the context of now this key question of has it been made, they're going, no, this is at the boundary. This is not as straightforward as you might think if you just said it's a claim to a chemical compound that doesn't, it's isolated. Having said it lies at the boundary, they're now obliged to go into those factors, to do the factor analysis. So let's have a look at what they did when they did the factor analysis. Well, actually, that's what that says. So because it lies at the boundary, we have to do the factor analysis. But actually, just before I move to that, I shouldn't have jumped in my words. I should have stayed with this, because it's quite important, as you'll see in a minute, for Chief Justice French concerned about, is it the legislature or the courts who should do this? Because what they've said is, it lies at the boundary, and it lies outside the boundary of the standard understanding of patentability, and therefore, if we, the court, are to say claims to 1 to 3 are patentable, it's a question of we're including it in. Okay, now I'll come back to that, including in rather than excluding out. A lot turned on that for at least one of the judges, I'm sure. So the question was, now, would we include into that which we've treated to date as patentable the claim subject matter properly understood 1 to 3? To know the answer to that, we do the factor analysis. Here we go, factor 3. And factor 3, remember, is about whether patentability would be consistent with the purposes of the legislation. That is to say, would it encourage, not stifle, innovation? A couple of observations that seemed important to the court and seemed therefore to drive it to the conclusion. Gavin highlighted a couple of these in his comments. Covers a very wide class of compounds. Gavin explained that extremely well. Claims could be infringed without the infringer knowing. At first I used to think, well, what's the relevance of that? Like, since when did patent law ever require that claims to be valid had to be claims that an infringer knew was infringing? I thought, oh, that sounds a bit weird, but I think I understand now. Claims not subject to a process limitation. All those 3 dot points, which are ones that the court highlights on factor 3, are telling me the court's saying the substance of this claim is right at the far end of high-level abstraction. If you think of claims as being on a continuum from extraordinarily low-level abstraction, fine-grained specific detail, through to the opposite, high-level abstraction, these claims are right at that far end. And this is what computer-implemented invention claims often suffer from as well. this is this bit about the information. They're inherently informational. They're really claiming information through some means that hasn't really been made by the patentee. Okay, so that's how I read the factors that influence the court on the issue of whether or not to allow patentability, to bring the claims into patentability, would be consistent with the purpose of legislation. The fourth factor, which is the one about coherence, they didn't actually, as far as I could see, say anything about it. They said it was a factor, and then I couldn't find where they applied that factor. But it's by implication, it's clear the court felt that to bring the claims into patentability would not be coherent with existing Australian law. And I mentioned Apotex and Sanofi for this reason, because in Apotex and Sanofi, this was, again, Chief Justice French talked about the need for coherence. And we can know what he means by it, because in Apotex and Sanofi, he did give real statements about this. In Apotex and Sanofi, question was, would a method of medical treatment be inherently patentable? Would it be a manner of manufacture? And as we know, the majority there, not every judge, but the majority of the judges said yes. And one of the reasons was because it was coherent with existing law on patentability. That coherence being as follows. We allow the patenting of pharmaceutical products. What are pharmaceutical products for? Treating people medically. So it would be incoherent if we were to decide, nevertheless, we won't allow the patenting of methods of medical treatment using pharmaceuticals. Okay, so I say that to give you an example of what they mean by coherence. Otherwise known as analogical reasoning, or what you might call logic or common sense or clear thinking. And it must be that they're inclined to think that analogical reasoning here has been held against the claims. I think the implication is these claims, if to be made patentable, would be an example of incoherence compared with that which we currently patent, which I think is really important when we get to what's left out, what is now clearly excluded. Factor 5 is not primary, but nevertheless got considered by the court. And what the court said was there would never been a suggestion made to it that Australia would be in breach of its international obligations were it to find, as it did, that these claims weren't patentable. Now, as we know, all of us know in the room, Australia's international obligation, primarily through the TRIPS agreement, but also through some free trade agreements, is that we have to grant patents for inventions in all fields of technology. But essentially what the court's saying here is, we're not told what inventions are. That's what we're answering with this case. So although we have to grant patents for inventions in all fields of technology, there's no international diktat about what an invention is. That's why we're deciding. And not only that, but when you look at how other countries do that, how they decide what is an invention, the High Court found no harmonised position. Now, it's not to say that if they had that would have changed their mind. The fact that they called it a secondary consideration suggests it probably wouldn't have. But they looked and they said, well, there aren't really. They looked at Australia's major trading partners and said sometimes the position seems reasonably clear that this sort of claim is patentable, say, for example, under the European Patent Convention. In other countries, say the US, it's been made clearly not. If we were going for harmonisation, there's no harmonised position to go for, so this factor simply did not count either way, it seemed to me, on the decision making. And finally, on factor 6, which is about, is this a question for the court or for the legislature? A very interesting conclusion by the court. Firstly, they said, because Myriad had pointed out to them, as Gavin reminded us, there's been quite a bit of consideration of this, a couple of Senate inquiries. Many of you in the room have been involved in this, I know. A couple of Senate inquiries, a draft bill, an ASIP review of patentable subject matter, and Myriad has been saying to the court, well, you can see from all this that the constant refusal of the legislature to do anything is mandating that the current position is right, and the current position is IP Australia's been granting these patents, so that must be, if you like, the legislature speaking. Court said no, cannot get an implied mandate there. Okay, and this second point is the question is one of inclusion, not exclusion. Now, if it's one of should subject matter that's on the boundaries outside the tent, if you like, be brought in, that's a question the courts are allowed to answer. and they're going to go and answer it, and they answered it, and they found the answer was no. But they're saying, if the question was, this is subject matter inside the 10 of patentability, but should it be excluded? Well, that's for the legislature. And, you know, those of you who've been around this so-called gene patenting debate, which the High Court also said this isn't a case about, know that it's often about excluding the subject matter, saying, well, there's moral or policy or economic or social reasons why it should be excluded. And the High Court would say that's not for us to decide. So I think the implication is we're not going to find a High Court particularly interested in a generally inconvenient style argument if that ever had any legs in the future. But it's a question of inclusion. That's one the Court's up for. Court did it, applied factors 3, 4, 5, factor 6 said it could do it, and the answer was no, not to be included, not subject matter for which a patent can be granted. So here's our so what now. I think with that we can get to the so what. Well, in general terms, I would say these are 3 major takeaways to be reminded of. The Court did not talk in language like the US Supreme Court did. It wasn't talking about a law of nature exclusion. Okay, it's really, it's quite clear. I mean, they almost bent over backwards to say, you know, at one point they sort of said, well, what the Supreme Court did is not relevant, you know, it's a different law. And they actually made a very sort of rather rude comment, said, well, the Americans aren't interested in policy considerations, whereas we are. So they distance themselves totally from the American Supreme Court approach. But the fact that this subject matter was related to nature was not irrelevant, and in particular it was particularly relevant because it raised the question of whether you could say this subject matter had actually been made. Okay, so although naturally occurring is not a ground of exclusion, it's relevant because it raises the issue of whether you can say the subject matter is made. Secondly, we must not get too caught up in it. As attorneys and lawyers, easy to forget, you know, that the claims are going to be decided by a court who's going to look at them a little bit more arm's length. They're going to be striving to look at substance over form, and it's in the substantive sense that the policy considerations get applied, not in the formalistic sense. And those policy considerations are at the very heart of the question. You can't ignore them. When you've got subject matter that's at the boundary, you must engage with them. And my final slide is this, about so what then specifically for biological material, leaving computer implemented inventions for another day. IP Australia's draft practice note, which Lexie will talk about in just a moment, said that the effect of the decision would be, or their draft practice note was to implement a decision along the lines that only naturally occurring coding material was excluded, the consequence being that naturally occurring non-coding material was not excluded. I might wonder if that approach isn't, unfortunately or fortunately, it's for you to decide, but in a sense it doesn't really matter whether it's fortunate or not. I wonder if that's not actually too narrow. My feeling is when I read and try and discern what the Court's on about here, I suspect actually they're saying it's not a question of coding versus non-coding. I think they're saying it's a question of whether or not you can say the patentee made the invention or not. Myriad didn't really make the invention. Myriad found out what the BRCA1 and separately BRCA2 gene mutations were, etc., but didn't make. I think actually that naturally occurring non-coding material could equally be said not to be made. I think that naturally occurring non-coding material could equally be said to be at the boundaries of the concept, and I think it could equally be said that those factors 3 to 6, when brought to account on naturally occurring non-coding material, militate against their patentability as well. So I'll hand over to Lexie to hear IP Australia's view.
On behalf of IP Australia, I'd like to take this opportunity to thank Gavin and Davies Collison and Cave and AusBiotech for the opportunity to be here this afternoon to talk about the Myriad decision and the processes that IP Australia has put in place in wake of that decision. With me here this afternoon is Dr. George Vukovic. George is a member of the IP Australia Executive and one of the Deputy Commissioner of Patents. Please don't hesitate to catch up with George or myself later this afternoon if you want to discuss any issues related to the Myriad decision or raise any matters that you may have related to any of IP Australia's businesses or practices. We would like to be here today with a finalised position on what we think the Myriad decision means, and give you a bit of some idea of what subject matter we think may no longer be eligible in light of that High Court decision. But there's no scoop, unfortunately, but we are very close to formulating our final position. So the role of the Commissioner is to understand the law and apply the principles of the law to the range of cases, applications, patent applications that become before us. The Commissioner is aware that there's a little bit of uncertainty created around this decision, and she is taking a little bit of time to determine the full implications of that decision. And we had about a week's notice before the decision was handed down that it would be so, and from that time, a week before, IP Australia has suspended examination decision making on a range of cases, and it's not only genetic technologies. The reach of our suspension and deferral of examination reaches into a lot of other biotech inventions. So at the same time, the Commissioner developed the practice note, formulated an initial position, and sought feedback on our approach. So essentially in that practice note, as Gavin mentioned before, our position was that coding DNA and RNA, coding nucleic acid from any organism, human or otherwise, and cDNA was no longer patent eligible. And so it doesn't tie up with what we've still got on deferment of examination. But our approach was those that we thought were clearly invalid in light of the decision. We would start with that and then go to public consultation, as we have. So I know that some of you here tonight did put in submissions. Thank you very much for doing so. So if I turn to the submissions that we've had 24 submissions, and the majority of those submissions are from legal professionals, attorneys, and relevant associations. So about half of those submissions could be reasonably characterised as being supportive of the position that the Commissioner went to public consultation with, namely that the reach of the decision is rather narrow, so it relates to nucleic acids and not to other material. And some of those submissions, most of them, relied on paragraph 6 in the judgment, which says, despite the formulation of the claimed invention as a class of product, its substance is information embodied in arrangements of nucleotides. There was also a view put forward in one of the submissions that IP Australia's approach was in fact too broad, and this is a little bit reflective of what Gavin said earlier. A distinction between there should be a distinction between nucleic acids encoding a therapeutic and nucleic acids that encode a diagnostic and used in the diagnostic context. So a nucleic acid encoding a protein, say as insulin, that was a view that might be still patent eligible, whereas nucleic acids vis-a-vis the BRCA nucleic acids in the diagnostic context would no longer be eligible. And another submission was we were not all cDNAs should be patent ineligible, and reliance on that was in the majority decision at 89, where, and I'm quoting the words of the majority, cDNA covered by the claims which is synthesised but replicates a naturally occurring sequence of exons. So there was emphasis placed on some submissions that only those replicating sequences that have occur in nature should be exempt from eligibility. Another submission spoke about the chilling effect that a broad exemption, a broad exclusion of subject matter would have on the biotech industry in particular, and other sectors, other industrial sectors. The other dozen or so submissions were not at all supportive of the Commissioner's position, in that they, the essence of those submissions was that the Commissioner's approach was too narrow, and the universal theme in those all of those dozen or so submissions was that the exclusion should be extended to non-coding DNA. So junk DNA, promoter sequences should also be impacted by the decision and should no longer be considered to be patent eligible. Some of those submissions that weren't in general agreement with the Commissioner's approach went further, and the submission was made that microorganisms, proteins, polypeptides were covered by the exclusion. And the majority of those submissions relied on the minority decision of Gagler and Nettle in support of that view. So public consultation has finished. We are close to concluding, coming to a point of what we think will no longer be patent eligible, and how we will apply what those principles are, and how we will be applying them in future cases before the office. And so we're thinking in a number of weeks, certainly before the new year, a new practice note will be communicated and published, along with all those non-confidential submissions. So 22 submissions will be available online after our practice note is communicated. The Commission is very mindful of the uncertainty that is happening to those of you who are prosecuting patents, and those of you in the audience tonight that maybe impact those from industry who are impacted. She is very aware of that uncertainty. So anything that's deferred, there is the option of extension 223 2B is available for to provide an extension of time. And we've processed over half a dozen so far requests for extension of time for those applications who are coming close to the final date for acceptance. So in summary, we're very close to going to the public, communicating our position. Thank you very much.
Thanks very much, Lexie, and thank you very much, Andrew. We'll just open the discussion up to questions now from the floor. If anyone has a burning question they want to ask.
I think I agree with most of what you said. In particular, I agree that it'll have an impact on computer-related inventions. That was something that I thought was a real worry right at the beginning. And I also agree with you that, possibly it's going to go wider than just the DNA to the other sort of, naturally occurring materials. I could go on on about it for a lot, but one of the things that really, I'll just give a comment first, one of the things that really struck me at the hearing on the second day, one of the first questions that Chief Justice French asked David Chapman was that maybe NRDC isn't the answer in this case. And I thought at that moment that NRDC would no longer be our law. And it was really interesting because the argument all the way along had been that this is all about NRDC, and they didn't really have to argue about anything else because it was just going to follow NRDC. But they did exactly that, as you noted. They sort of sidelined NRDC a little bit, although they've incorporated in those principles. But if you still think about those first two principles, if you applied just those on their own, I still think that the isolated DNA, even though it wasn't made, in the sense that they use the word made, it satisfies something where you've had human intervention and it's something that has utility. So they had to come up with a test other than the NRDC test if they were going to find that it was not patentable. And yes, that's really my comment, one of my comments. But one of my questions for you was that you've distilled sort of the principles and the points that you've made from that majority judgment, and because the other judgments are different, I really just wanted to know what your view was as an academic as to what we should be taking from the other judgments, if anything.
Thank you. The comments are very well made and ones that I share. I think that it wasn't so much they sidelined NRDC. I think they just went back and reminded me that NRDC had always said that this is a policy-based question. Here's a bit of a set of principles or factors, but you know, unless that solves the problem straight away, if you're at the edge, you've got to do more. And so I think they were very clever in doing that. What to make of the other judgments? Look, it's a really challenging issue for me. I mean, I have read them. I haven't read them as closely as the judgment of the four that I spoke about, but I have read them. And part of me sort of thinks, well, I just want to deal with one judgment that's really hard. I don't have to deal with two others. You know, so I want to be intellectually lazy. Another part of me says, there's bits I don't like arrogantly don't like about the other judgments. And what do I mean by that? Well, and because of that, I'm sort of, if you like, speculating stroke hoping that we can just focus on the four. I think if we start to bring in the other three, we're in more messy environment than ever. So I'd want us to be able to say, look, that stuff's enough. So we have to bring in Gagler and Nettle and the final judgment as well, Justice Gordon, and I would hope not. But Gagler and Nettle to me seem to be, it's very hard to put this politely, they seem to be all over the shop. I mean, they started talking about Mullard and Philco. They were talking about fair-basing issues. They said that we do have an on-the-face inventiveness threshold test as part of our manner of manufacture test. And I noticed that the four, Justice French and Chief Justice French and the other three judges, did not do any of that. So that, to me, the person who doesn't like the idea that we have on-the-face of the specification inventiveness, Gagler and Nettle say we do. The person who says, look, what's fair basis got to do with this? They seem to want to bring it in. So I think that judgment, if you're looking for a way of sort of damning it, I'd damn it that way. I know that's terribly rude and arrogant, but that's how I would damn it. And Justice Gordon's judgment, I'm even less clear really what's driving that. So I'll just plead ignorance and say I'm sure I haven't properly understood what she's saying, and so I'll ignore it on that basis. So the short answer is, I hope we could ignore the other three judges, the other two judgments, because there's enough to deal with in the judgment of the four. And at least in one of those other two judgments, there's stuff in there that I think makes the position even vastly more complicated, less uncertain than we are with the judgment of the four.
Anybody else? So if I can just one question, Andrew. You've elevated the concept of made to be really important here. So how do you reconcile that then with the exclusion of cDNA? Surely cDNA is made.
Yeah. Well, again, a really good question. And I think here what the judgment made me do was be less simplistic than I have been in the past. So I was sort of quite, until required to, I think I probably was just nodding quietly going, yeah, this stuff's made. You know, it's an artificially created state of affairs. It's been extracted, isolated. What more do we want? And now I think I see what it is that the judgment of the four are telling us that we need. I'm not sure that that's going to satisfy their definition of made. And if I may, maybe let me elaborate how I'm now left to think about that concept. And I'm left to think about it in a way that where I would, for my benefit at least, if not, it's not a legal test, but just a way of sort of rule of thumb in my head, think about it, is how would an intelligent person in the street think of it? Because that's actually how I think the High Court judgment did. And if you said to an intelligent person in the street, do you think that Myriad made its invention? When you tell them what the invention is, they say, no, they didn't make something, they found stuff out. And I wonder with cDNA whether you've got exactly the same response. Did you really make that, or did you just find stuff out? When you look at the substance of what you're talking about, not the form. So my take on it is, making does a lot of work here. Making needs an elaborated understanding. It's not enough to say person kind intervening in nature so that there's now something different from nature. You need more. I think you have to be able to say, A patent is warranted because we have an inventor. We have an inventor because an inventor has made something, and that made or making concept is very much a person in the streets one.
I'm going to Andrew. You made the comment that the High Court justified methods of medical treatment based on we have claims to the substance that we use to treat. Can we use that analogy and say, well, we allow methods of diagnostics, why can't we, or molecular diagnostics, why can't we claim off the agents that we use, or the targets that we use for those diagnostics?
Yeah, great question, Trevor. I think the answer goes like this, that the method claims are inherently further down the continuum of high level of abstraction to low level of abstraction. They're more implemented, they're more narrow, you know, for want of a better way of putting it. And so if you were to try and say the coherence works this way, we've already allowed the patentability of subject matter that's, say, in the middle of the spectrum of how far between very high level of abstraction and low level. The coherence suggests that we should then extend it to the high level. Doesn't work. And I think when you, because in Apotex and Sanofi, the coherence went the other way. We allow the high level abstraction claims to the molecule, the compound that does the thing, and then we'll allow a more narrow version of use of compound to do a particular thing more narrowly specified. So I think the short answer is you can try it, but if I'm understanding this concept of coherence, and if I'm understanding what's really the objection with this claim, it's just way too high level of abstraction, way too broad, way too general, way too far away from where you could sort of be confident in saying an inventor has made something. So I think it's not going to work. You're not going to go that way.
Anybody else? Comments? Questions? Yeah.
Just, I'm curious why, it's just short, I'm just curious why algorithms will potentially fall under the category of being at risk, because surely they're artificial and they're made. So I just want you to...
Well, thank you for asking. I think they highlight even better in a way what it is that this concept of making needs to be and why they aren't. Yes, you could say the algorithm was artificially created because it wasn't. Someone had to come up with it. I think that's a little bit like saying Myriad, artificially created their isolated coding sequence because they had to isolate it. But it's not enough. Is an algorithm an artificially created state of affairs? No, I think the court is going to say when you properly understand that concept, no, because you haven't made something here, and you haven't. What you've done is you've found stuff out. Now, I'm struggling not to use the word made and discovery, because we know that the High Court and other courts have often said that distinction can be very fallacious. Discovery. So it's very easy to think that this difference between an patentable invention and unpatentable invention is that you have an invention versus a discovery. But that just leaves all the hard work to be done by the word discovery. What do we mean exactly? So I'm not going to use that. But I think that is, if it helps, that is the problem. You have discovered some fundamental high-level abstract concept which you embody in an algorithm, and now you're saying, and I've made something, I've got a product that is worthy of patent protection because it will be a general purpose computer that implements that algorithm to do the thing the algorithm does. I think that is equally, if not more so, clearly at the far end of the spectrum, beyond that which is clearly within the tent. Okay, so I think you'd have, if we had a robotic Chief Justice French here and fed that data set to him, he would spit back something like, that lies at the boundary that we need to apply the 3 to 5 factors 3 to 6, we apply them, we find. And I reckon you could almost map the same sort of things, breadth of claim, what falls within it, people don't know they're doing it when they're infringing, etc., etc. International position, not clear, not mandated and not clearly harmonised. Coherence of the law doesn't suggest that this one just follows from what's gone before. I think you're going to find equally, if not more, problematic.
I think the issue with the Myriad claims where they were very broad, I mean, what would your view be for a claim to one molecule that covered off one mutation? So, for example, could only be 20 nucleic acids for that mimics the naturally occurring mutation. So, a very narrow claim.
Well, thank you for your asking, but I don't claim to have all the wisdom. I'm sure this response is not going to be of any significant value, but I don't think that's going to pass muster either. I think the problem is you haven't made something in the way that I'm hearing, I should say more accurately reading the court to say you need to. So this is why, I mean, as I say, I'm the messenger, not the author of the message here. And I know, because I've had enough chance to chat to people during session, have questions elsewhere where we've spoken about this, to know this is going to be potentially, if that's right, I'm not hoping it's right, I'm just saying if it is right, this could be potentially really problematic. And I've heard people say very passionately, well then where's the incentive for us to do the work that will produce these very valuable outcomes? And I can buy all that, And maybe the problem is that the High Court is the High Court. The High Court isn't sitting where maybe the people who want to change this, if this is the way it is, may have to change, you have to go, which is to a legislature. And say to a legislature, when you do a proper analysis here of what's in the national interest, are we going to get the things we want to get, etc., well, you may have to change your law if it becomes like potentially it could, as the way I've described it. But that's not the High Court's job. I mean, so you can criticise the High Court, but it's not fair to do so. The High Court isn't an economic policy-making unit. It isn't a legislature. It isn't able to do a case-by-case analysis with great precision. I'm not sure anyone could either, but it certainly can't. Its job is every 48 years to hand down or remind us properly of what the principles are, and then leave it for poor buggers such as IP Australia, attorneys such as you, and clients such as you in the room to have to put up with the day-to-day consequences of it. But that's a bit of editorialising to a very short question. So I'll go back to the short answer. I fear the answer is it's not going to pass muster either, because you've got the same problem. In that situation, you didn't make something in that sense that I read the court as meaning it. You've found stuff out, and that isn't enough. Now, hopefully wrong.
I think last one, because we're running out of time.
I just wanted to pick up on that point that you made about perhaps if there's going to be any change, it should be a change to the legislation, and really what the chances of that are. And it's always seemed to me that part of the problems that arise because we're in the dark ages, because we pull in the definition of manner of manufacture from the statute of monopolies. Everyone else got rid of it. The UK got rid of it. The US got rid of it. And I just, I wondered whether it could be, somehow how difficult it would be to fix it, maybe by getting rid of something like that. And the other thing was just picking up on that point about inclusion and exclusion. The legislation already excludes certain things from patentability, including the ones to do with IVF type things in 1802, and it's always done it by excluding it rather than including it. So it's really odd to me that the High Court's taking this inclusion approach. And if you were going to legislate, then how do you do that by inclusion rather than exclusion? Thank you.
Again, a really important point, and I wish I was all wise and all knowing. I'm not, so I can't offer you great insight on this at all. But other than to say you're really on the back foot now. I mean, now think about it. Those who wanted this decision to be the law before it was even the decision were on the back foot. They had to go to Parliament and say we should be excluding these types of claims from patentability, and look where they got. Nowhere. A couple of Senate inquiries, an ASIP review, an ALRC review, a draft bill, got nowhere. Because trying to move from being seen as the non-default position to where you want to be is really hard. If the reading that I give it is a reasonable reading, and if that is adopted and understood to be roughly what the law is, then you're on the back foot now. You're right on the back foot, because you're going to have to go to the legislature and somehow or other persuade it that it's really important for our economic well-being, as well as to be delivered all the useful medical products we want, that we bring back into the tent this sort of claim, or at least something that's not as egregiously wide anyway. Certainly stuff that, even if it's naturally occurring, nevertheless there's been some intervention, etc. But that's going to be tough. We've got a gridlocked legislature, not quite as bad as the Americans, but not particularly good, and you're starting from the position the default now is against you. I think it's really tough. I heard someone suggest in a seminar a month or so ago that when they were asked the question, or maybe implementing the ACIP recommendation, for which I can say I was heavily involved in, would be the solution. But I don't think that would be. I mean, as much as I'd like to say, yeah, that's right, I got it right, last year or the year before, I don't think that would be, because the ACIP solution simply said, change nothing, keep the principles we've got. We just said you could use clearer language, namely an artificially created state of affairs in the field of economic endeavour. And the High Court's told us that's not enough. That's just the first 2 of 6 factors. So even implementing ACIP's recommendation, I suspect now, wouldn't get you or whomever wants to get to that position. I know it's not necessarily you personally, but those of you who want to change the position away from what it might be are on the back foot. It's a hard ask. Legislative change through definition of manner of manufacture a la ACIP probably not going to get you there. You probably have to go for some sort of inclusion restatement, which is tough.
All right, thanks very much. I think we'll have to leave it there. We're running out of time. We've got to get this room turned around pretty quickly for our drinks event coming up. So once we do wrap it up, I'd ask you if you could all shift out of the way of people moving chairs. We want to get you or get a drink in your hands as soon as we can. We can continue the discussion at that time. Before we go, firstly, just a big thank you to Andrew and Lexie. Thank you very much for your time and for coming along. Thank you to all of you for coming and for your attendance as well. Finally, we'll have some words from Anna Lavelle, CEO of AusBiotech.
Thanks, Gavin. Now that was all clear. I suppose you now are all experts and you can tell your friends all about it. I'm very relieved that we've got to that place so quickly. This is why AusBiotech highly values our legal experts as members, and we really need that technical advice. Clearly we're not as versed in these areas as Andrew and others, so we do rely heavily on firms to assist us, and people like Gavin and many others in the room to assist us with these sorts of determinations. AusBiotech's been really thickly into this for a number of years now, and sadly I probably know more about this subject in tax than I ever thought I would as a molecular biologist. But it's been a very interesting journey, and I'm not unsympathetic to IP Australia, who've had a barrage of issues to deal with over the recent few years, and I think, from our point of view, looking at the extensions and dealing with the current situation is good to see. So we're very happy about that from an industry point of view. Obviously, I feel quite sad for Darcy and others who were taken through this process. I think my personal view, not the view of AusBiotech, is that there were those that used this woman and others as a tool for their own agenda, and she and others feel that they have righted an evil, done a magnificent thing of getting free treatment for women, and that is clearly not what has occurred. And I just think the misrepresentation has been appalling, and I would say that that's the same for the legislature. My experience of going around Parliament House is that many of the ministers and others were told, in my view, my personal view, outright lies about what the changes that were proposed would deliver to the community and what the evil or the potential evils were. And I really think that that's playing the man and not the ball, taking your eye off the argument and really going for a personal agenda, some of which was guided by religious beliefs and not by law or by science and or medicine. So I think that we just need to be cognizant of that and obviously not support that, but also it's very important to get the technical interpretations from people who have taken the time, and thank you for that, of going through this judgment, because I certainly didn't want to read it in that sort of detail. So I do appreciate that somebody has and are trying to explain it to us. We had a meeting at AusBiotech with 8 of our legal firms, patent attorneys and patent litigators, including DCC, and we're very grateful for that input, because it helped us formulate a view as to what potentially this decision could mean, although I take it, with some of the comments today, that there's still a long road to hoe in terms of really coming down on what it will mean in practice for us. And in terms of the so what, that's all industry cares about, Andrew. We don't care about the rest. And the rest of us, I really think that it's nice having these academic interpretations, and I used to be an academic, so I'm allowed to say that. But in reality, what we care about is the patient, we care about the community benefit, we care about the economic benefit, and we care about supporting innovation in this country and also supporting researchers. And that's where the rubber hits the road. And for us, you can see that there's some frustrations, of course, in terms of, the finer details, which sometimes we feel is obstructive because it gets in the way of those higher order issues. But nevertheless, we're all in this together. And I think that as a team, we should be able to work it out with the legislators and the administrators and the lawyers and the industry and the academics, all working together to try and come down to what is a sensible, workable, long-standing resolution, so we don't have to have another 4 Senate inquiries. So thank you very much to DCC and Gavin in particular. We really appreciate the partnership we have with DCC and with those of you in the room, and thank you to our members. Please stay, hang around. DCC have promised to give you something alcoholic, which we know that you will need after such a hot, blustery day in New South Wales. So thank you all very much, and thank you too for the support that you give us and help us represent you. And if that means going back to the legislators, well, that's what we'll do. Okay, and Merry Christmas to you all.